Yeah, good afternoon, everybody. Welcome, and thank you very much for joining us for this Center for Comparative and Public Law Human Rights Seminar. I'm very pleased to welcome and introduce Dr. Jonathan Kolieb from RMIT University in Australia. And he's going to be talking to us today about quite a topical subject, and I think from the abstract it seems he'll be making some very provocative provocative arguments, so I'm sure will generate quite a lot of discussion. Jonathan has done a lot of things in his career. He's been an external legal consultant for the UN Office of the Special Representative of the Secretary General for Children in Armed Conflict. And he's also been a research partner for the Australian Red Cross. So in addition to his very prolific academic CV, he's gotten involved in many of these issues at a very real level. Yeah. So anyway, please join me and welcome.
Thank you very much, Kelly, for the introduction. It's a great pleasure, it's a great honour to be here. I was telling Kelly on the way over that I wanted to walk past the
Pillar of Shame.
The Pillar of Shame, your Tiananmen Square massacre memorial. I think there is something courageous about talking, studying, teaching, thinking about human rights in Hong Kong. It's far more courageous than doing so from Melbourne, Australia. So I'm here to say thank you. So my name's Jonathan Kolieb. I'm going to talk about the Business and Human Rights Treaty, and in particular the scope of the Business and Human Rights Treaty that's currently being drafted by the United Nations. I realise on the poster it wasn't quite a sexy title, so I sexied it up for the PowerPoint. So the Business and Human Rights Treaty, dead on arrival, ? And I think that sums up the problem that I seek to address in this presentation, and really, and hopefully a paper that comes out of it. This is obviously just a working paper. I really would value your opinions, your thoughts, your feedback, and your criticisms. Okay. Also, just want to thank the Centre, Winnie, Jed, Elizabeth. There was a whole chain of folks that helped out to make this happen, so I'm very appreciative. Another opportunity for me to share some of my ideas. Okay, so what are we talking about? Let's sort of set the scene. Do me all a favour, a bit of audience participation. Pull out your phones. I'm the only lecturer that'll ever ask you to do that. Pull out your phones. Did you ever wonder what makes those vibrate? Did you ever wonder what's the technology inside? What makes it work? Well, in particular, there are what's called 3T plus G, tin, tantalum, tungsten, and gold. 4 precious metals that are absolutely vital in all of our iPhones and Samsungs and Huawei's and all our modern telecommunications devices, in particular the thing that makes it vibrate, believe it or not. The problem, perhaps, if we can call it a problem, is, permit me to do so, is that the source of so many of these minerals is the Democratic Republic of Congo and surrounding countries in Central Africa, which, as I'm sure we all know, has unfortunately been racked by conflict for decades. One of the longest running armed conflicts on the planet, literally millions dead, and even spin-offs of conflicts come from it. So the things that make your iPhone work could be derived from a mine like this one in the DRC, Democratic Republic of Congo. And those mines all of a sudden became extremely lucrative possessions, fought over by militias, by government forces. They became a source of armed conflict, of violence, of human rights abuses. there in the DRC. To me, I think that encapsulates this problem, if you will, or the, generously speaking, the uneasy relationship, shall we say, between business writ large and human rights writ large. An illustration of one business practice, one industry that, by virtue of where its supply chains are traced to, was complicit, arguably, in major egregious human rights abuses. This is, unfortunately, just one illustration of many, many companies that are aiding and abetting serious human rights abuses all over the world. The notion of regulating business is not a new one, and certainly the problems of how to better regulate businesses within the human rights discourse, the human rights regulatory environment, really are illustrated by these, unfortunately, worst case scenarios, if you will. There are some positive business and human rights stories, but let's, for the setup, dwell on the negatives. All of these are images of current contemporary business and human rights issues. One that I enjoy my soccer. Qatar is hosting the 2022, I think, World Cup. They have been accused of, allegedly, by the way, should be the subheading of this entire presentation. Yes, that's my caveat, ongoing caveat. They've been, there's been allegations levelled against the Qatar organising authorities of all sorts of labour and human rights abuses, unpaid work, unsafe work conditions, almost amounting to indentured servitude in some instances. There's clear felling of forests, impinging on people's rights to their own farms and property, as well as a right to environment and clean water, that is occurring across Southeast Asian countries for the planting of palm oil, or just clear felling in order to create new factories. The two down the bottom are, I think, quite compelling. The factory on the left is a cement factory in Syria. It's owned and operated by one of the largest cement factories, which happens to be a cement company, Lafarge Holcim, a French domiciled multinational. And they have been accused in a French court right now of bribing ISIS to keep it open, Islamic State. So, yeah, I think an interesting, to put it neutrally, illustration of the interplay between business and business operations and human rights abuses and human rights concerns. We're talking multi-million-dollar bribes as well. So they've been, they're up against charges not just of corruption, but now of complicity in war crimes. And on the right is a picture of, does anyone know what that beautiful little village is? That's an Israeli settlement on the West Bank. Israeli settlements under international humanitarian law are illegal under the Geneva Conventions, and Airbnb last year, the company that rents out houses, they had hundreds of listings on Israeli settlements in the West Bank. They were pressured to withdraw, and they announced that last year that they indeed were not going to post any more house listings from the Israeli settlements anymore, because they did not wish to be complicit in a continuing violation of international humanitarian law. Really interesting, I think, illustrations of the interplay between business and human rights. There's also the Niger Delta and gold refining in the DRC and Central African countries is unfortunately a perennial problem in this space. Nevertheless, there has been increasing acknowledgement, really, I mean, certainly since the turn of the century, if not earlier, that to solve so many of the world's problems, we need business on board. Business has been acknowledged as a potential stakeholder in not just preventing human rights abuses, but actually realising those aspirational ideals of the human rights movement. We need companies in the private sector to partner with government, civil society, to tackle these large development and sustainable development and human rights issues. Ban Ki-moon there spoke about sustainable development. He's also on the record of suggesting that also human rights challenges need companies more involved. The rubber really hit the road in 1999 when the UN Secretary General Kofi Annan went to the most liberal and open gathering of the world's elites in Davos, Switzerland, the World Economic Forum. In 1999, he got to the podium and to the world's elite, to the leaders of global industry, he said, we need a new global compact between business and people, business and the planet. It's simply not working. That was 1999. A few months later, the UN Global Compact was launched by the United Nations in New York. A series of 10 statements, including 2 that relate to specifically to business and human rights. Principle 1 indeed says businesses should support and respect the protection of internationally proclaimed human rights. And Principle 2, they should make sure that they're not complicit in human rights abuses. UN Global Compact is perhaps the most famous of the large proliferation of voluntary soft law instruments that seek to respond to this problem of businesses being involved in human rights abuses, or more generously, businesses at least not living up to the potential of protecting human rights. All of these logos refer to other voluntary multi-stakeholder initiatives, some led by civil society, some led by business themselves, some led by governments. UN Global Compact, for its part, I think is a nice case study. It's entirely voluntary. It's got over 8,500 companies that have signed up at last count, last time I checked anyway. And they are supposed to file a report of their progress in fulfilling these 10 principles, such as have they avoided being complicit in human rights abuses. There's no accountability, there's no enforcement measures, other than if you do not file the report, you get delisted, if you will. The author of the Global Compact, John Ruggie, calls it the largest business educational project on the planet. Think CSR, but in regulatory guise, corporate social responsibility, but in regulatory guise. Okay, so these are all voluntary, market-oriented mechanisms. Back at the UN, though, in fact, for many decades at the United Nations, they've been grappling with, well, but what about hard law? Can we do anything on the hard law side of things to regulate business's relationship with human rights? In particular, should there and could there be such a thing as businesses' human rights obligations? So rather than should or might, must. Businesses must uphold human rights. Well, really these efforts go back all the way to the 1970s, actually, as part of the decolonisation movement. Whilst the developing countries, predominantly in Africa and Southeast Asia, saw the success by the late 60s and 70s of the political decolonisation movement, they saw the influx of Western multinationals as sort of the second wave of colonisation. And so they sought to respond to that corporate power by regulating it. So in 1972, it was proposed that there be a code of conduct for transnational corporations, multinational corporations. Indeed, by the early 1990s, so only 14 years of deliberation, at the UN, they actually came up with a code of conduct, and that was promptly shelved, and the commission that devised them was disbanded and defunded. That was the early 1990s. In the early 2000s, we came to another subcommission of what was then the Human Rights Commission that was tasked with drafting binding norms of conduct for global business vis-a-vis human rights obligations. So they came up with what was called the norms of conduct for transnational corporations and other business enterprises. That never made it out of subcommission. That never even got a vote at the plenary at the UN Human Rights Commission. It died a very quick and silent death. In its place, in the place of the latest, greatest proposal for binding businesses' human rights obligations, the UN created a entity called the Special Representative on Business and Human Rights to look into this problem, this wicked problem, if you will, that has bedeviled the UN and the global system for 40 years. How do we better regulate business? So John Ruggie was appointed for 3 years to come up with the solution. What did he come up with? Well, he came up with 3 words: protect, respect, and remedy framework. After many consultations with government, directly with business and with civil society, this was his product in 2008. Protect. States must protect human rights. Respect. Companies should respect human rights. Notice the changed language in that second pillar. And remedy, all victims of human rights abuses should have access to effective remedy. Protect, respect, and remedy. He got his mandate renewed for another 3 years to further develop how to operationalise this 3-word framework. And he came up with what's called the UN Guiding Principles on Business and Human Rights, which is this document here. It's a series of 31 principles which seek to give effect to how do I, as a business or as a government or as a human rights abuse victim, engage that protect, respect, remedy framework. What should I do as a business, for example? So principle 11, let me read it out to you to give you a sense of principle 11. Business enterprises should respect human rights. This means they should avoid infringing on the human rights of others and should address adverse human rights impacts with which they are involved. Notice the language: soft, should, non-binding, voluntary. That is at the essence of the, well, depending on where you sit, the genius or the chief criticism of the UN Guiding Principles. You see, unlike the norms, when this came to the Human Rights Council, it got unanimous support. Unanimous support. Every government on the planet supported and endorsed the UN Guiding Principles on Business and Human Rights. It was endorsed by global business and their relevant representatives. The problem for those that were advocating for binding human rights standards was, well, there's nothing binding about these guiding principles. In fact, if you think about the name, there's nothing, I couldn't think of a name that is more voluntary and soft, right? Guiding principles on business and human rights. So that quickly became, though, because of the government and business endorsement of them, that became the touchstone for the business and human rights discourse within scholarly circles, but also in boardrooms as well. The guiding principles on business and human rights. Certainly, it has not been a panacea. So just that's image of the Rana Plaza disaster from April 2013. That left over 1,100 garment workers dead. So the guiding principles, as much as they were fated in 2011, and as much as they have been adopted by governments, celebrated by business, if you go and have a look at any major multinational sustainability reporting, if they have an element of human rights reporting in it, they'll reference their adherence and their acceptance of the guiding principles. question became, for the guiding principles, now what? Is this the end of the business and human rights regulation story? Or is this merely a stepping stone to something else? You can, I guess, get a sense of where different stakeholders might fall. Business were quite happy if this was going to be the finish line, that yeah, they'll accept the guiding principles and they will do their best to implement them. Especially civil society critics as well as scholars said, no, this is merely a stepping stone and we should continue the efforts to harder, more stringent, more mandatory responsibilities of companies vis-a-vis human rights. In 2014, this dispute over where to next in the business and human rights conversation came to a head at the UN Human Rights Council. To treaty or not to treaty was the question put before the Council. And there were two competing resolutions. One put by Ecuador and South Africa said, let's draft a treaty and let's draft it today. Let's start the process of drafting a treaty today. Another resolution supported by Norway and supported by European and most Western states said, you know what, we kind of like the guiding principles. We much prefer an incremental, softly approach. Let's not waste the momentum of the guiding principles by jumping to a treaty. Incrementalism is the way to go. Both passed, strangely. Both resolutions passed. But it really highlighted, put into stark relief, the sort of also the benefits, if you will, of hard and soft law, or at least those benefits that were being advocated by both sides. As I said, the Human Rights Council decided in their infinite wisdom to do both, to adopt an incremental approach to the idea of businesses' human rights obligations, but they also funded and mandated what's called the open-ended intergovernmental working group on a treaty, on an international instrument on business and human rights. It's like a very long name. And sure enough, they got to work. And in July 2018, they actually released their zero draft. So not even a first draft, but a zero draft of that treaty. That's what I wanted to talk to you about today. Just before I get there though, I just again wanted to sort of step back and mention a sort of philosophical point of view, because there are incredible differences of what should be involved in this treaty, what should be captured by a treaty. And one of the big philosophical differences is the competing ideas of what should the role of a business and human rights treaty be. How do we see it within the universe of regulation of business and human rights? What is the appropriate role of this treaty? Is it going to be the first treaty of business and human rights, a first of many, or is it going to be the last? I think, well, one of my chief interlocutors, who happens to be a Hong Kong resident, says that Professor Surya Deva, says that the treaty should have 4 objectives. It should nudge states to act collectively on businesses' human rights abuses. It should address the asymmetry between the rights and obligations of business. Think the investor-state dispute settlement clauses in investment agreements currently, where businesses can sue sovereign states but cannot be sued themselves. It should respond to governance gaps in hard cases where no business case for human rights compliance exists. And it should enable states to enable access to remedy for victims and remove barriers for them to do so domestically. Okay. My response to Surya is that's a whole lot of baggage to be piling into one instrument that we have yet to draft, that the home states of most of the major multinationals that we have heard of, as well as the multinationals themselves, are fiercely opposed to. It's an incredibly ambitious objective for any treaty, let alone the first business and human rights treaty. I disagree with him. I think fundamentally purpose of this first Business and Human Rights Treaty should not be about signalling that businesses should respect and have obligations to protect all human rights, but rather it should be setting the floor. It should be laying down the minimum standards vis-a-vis their human rights obligations, that we will not countenance them violating going forward. The minimum standards. We should have modesty and humility. We should learn the lessons from those aborted efforts in the past for a binding business and human rights treaty. We should learn those lessons and come at the problem in a modest fashion. Setting those minimum standards. That, to me, is the role of a business and human rights treaty. I'll come back to that maybe later. That's a little bit self-serving. Unfortunately, the folks that drafted the Zero Draft don't agree with me. They think, and I'm going to zero in on the scope of the Business and Human Rights Treaty. If you adopt my approach of modesty and humility and laying the groundwork, laying the floor of those minimum standards, those core minimum standards, I would suggest that you need a narrow scope treaty. Instead, the Zero Draft says in Article 3, scope, this convention shall apply to human rights violations in the context of any business activities of a transnational character. 2, this convention shall cover all international human rights and those rights recognised under domestic law. The most broad a scope imaginable. All human rights are covered. All business activity of a transnational character would be captured by this current Zero Draft. There's another issue with the treaty, or another problematic area, which is the treaty actually only attaches indirect human rights obligations. So it actually doesn't place any direct, under international law, human rights obligations on companies, but rather obliges signatory states to give effect to the provisions of the treaty through domestic legislation. Let me zero in again on that broad scope. I think there are tremendous dangers, in particular 2. 1, the danger of illegitimacy, and 2, the danger of ineffectiveness. That you will not actually, if you embrace a broad scope treaty, you are in danger of creating a treaty that just sits on the shelf, that is not implemented. Those grand objectives that the business and human rights movement has set for itself will not be achieved, in my opinion. And indeed, in some senses, this is just a critique that's levelled against many human rights treaties. We were talking before about CEDAW and some other treaties. There are violations of those treaties that occur in many countries on a daily basis. Here we are pushing the envelope with a business and human rights treaty, and as the current Zero Draft stands, we are being even ambitious in our scope. I think we need a more precise, targeted scope for this treaty. And in particular, I want to suggest that we should be adopting international criminal law as a better frame of reference, a narrower set of behavioural standards, of norms of behaviour that we should expect, at a minimum, for businesses of any stripe, of any size, to uphold. So, if you will, egregious human rights abuses that amount to an international crime would be my suggestion for the scope of a treaty. I realise that there's a lot of critics out there and conversation about what should the adequate scope be. So I went back to the literature and tried to find some sort of framework from which to substantiate and justify my approach. Thomas Franck, very famously, American legal scholar, very famously wrote about the legitimacy of international law, the legitimacy of international rules. The premise of his life's work was that why does a state comply with international law? It's got nothing to do with an international police force or the threat of punishment, but rather the inherent legitimacy of international law prompts compliance. So that seemed to me to be a really important criteria for any future business and human rights treaty to try and have legitimacy. The other, effectiveness, well, Robert Keohane and David Victor, two IR, international relations scholars from America, have looked at international regime effectiveness. And they came up with 6 criteria that they suggest that international governance regimes should possess in order to ensure the best chances, the most likely chance of effectiveness. They were coherence, accountability, determinacy, sustainability, epistemic quality, and fairness. The nice thing about those 6 criteria is that they also largely reflect the 4 criteria that Thomas Franck developed as the essence of legitimacy, i.e. you possess these criteria and an international legal rule or an international law or an international treaty, I would submit to you, has legitimacy. So under Franck, his 4 criteria for legitimacy is determinacy, symbolic validation, which is akin to epistemic quality, I would argue, 3, coherence, and 4, adherence, that the stakeholders, relevant stakeholders, agree and apply it. I think when we apply these criteria to the question of the scope of the Business and Human Rights Treaty, we naturally come to advocate for a narrow scope Business and Human Rights Treaty, one that is based on international criminal law norms rather than the broader universe of human rights norms, which would encompass civil and political rights, economic, cultural, social rights, the rights of women, the rights of indigenous people, the rights of workers. You name it, there's a human rights treaty for it. As currently devised, the Zero Draft would oblige businesses to uphold each and every one of those human rights. So let me just spend maybe 10 minutes just trying to apply those frameworks, and maybe we can get into then some more in Q&A, in discussion afterwards. But so international criminal law, I think, has the advantage of reflecting the key norms, the elemental norms of not just international human rights law, but also international humanitarian law. So many of the most egregious human rights abuses that are committed by businesses, or that businesses are complicit in, occur in or around conflict zones. That is where people are literally dying because of business practices. Also, unlike the panoply of international human rights law, most international crimes are considered jus cogens, the peremptory norms of behaviour of which no violability should be countenanced. Now, a true jus cogens, if we're true to the meaning of what a jus cogens term, principle is, then surely that obligation not to violate it should not just fall on states, but on all entities, individuals as well as corporations. So there is a logic to that there as well. International criminal law also, if we narrow down the scope of the treaty just to international crimes, well, they're criminal in nature. So by their nature, they unlike international human rights. So by their nature, they are identifying more egregious behaviour that have already been criminalised. Not only that, but international criminal law envisages collective criminality. What do I mean by that? Well, international crimes allow for groups of people, organisations, entities to be held accountable, including businesses. There's a clarity to international criminal law that international human rights law simply lacks. Again, which treaty, human rights treaty, should we be referring a business to? If a business comes to you and says, how do we implement this new business and human rights treaty, our new human rights obligations, which treaty should they be looking at? With international criminal law, arguably, there's a singular text the Rome Statute of the International Criminal Law Court is, if you will, the definitive statement of international criminal law as it exists today. It's not vague and aspirational as many international human rights instruments are. It's couched in the language of prohibitions, which again, from a normative sense, the normative role of this Business and Human Rights Treaty, I think adds a great deal of clarity and determinacy, as called for by Franck, Keohane and Victor. I think in terms of accountability, which was also highlighted by those three scholars, by using a narrower set of norms, I think not only do you have a larger group set of pathways that are currently available for breaches of any business and human rights treaty by businesses, but greater opportunity to develop new ones as well. Indeed, because of the Rome Statute, literally over 130 countries have implemented domestic legislation criminalising international crimes. They are now domestic crimes in these local jurisdictions. Crucially, many domestic criminal codes apply to companies right now. So in terms of having viable accountability pathways from the day dot, from the day when a business and human rights treaty is signed, I think a narrow scope business and human rights treaty devoted just to those egregious human rights abuses that amount to international crimes is the way to go. And then finally, on acceptance, on adherence, which highlighted by these scholars, I think we really need to take to heart the lesson of the norms, the lesson of these stillborn past attempts to draft a business and human rights treaty. I agree in one sense that incrementalism is the way to go. After the guiding principles, Western states said, let's just stay with the guiding principles, let's not harden it up. Well, I would push the envelope a little bit further. I would say that we should have a binding business and human rights treaty. But I still think that we can maintain the legitimacy, garner the legitimacy of businesses to a greater extent than we could with a broad scope treaty if we narrow it down to international crimes. After all, what business wants to oppose being told they cannot commit or be complicit in an international crime? To me, those talking points don't really fly off the page. So if resistance for businesses and concerned governments was the big factor, that was the big hurdle that prevented a business and human rights treaty from being enacted to date, we should take that to heart. And rather than putting all our hopes and desires, as Professor Suryadeva would like to do, in this first business and human rights treaty, I say we should take a step-by-step approach. We can build in that step-by-step approach into the treaty, right? There could be a regular mechanism, review mechanism. Every 3 years we get together and potentially expand the scope of any such treaty. But we need that legitimacy in order for the effectiveness of any such treaty to occur. So these are the international crimes. Importantly, currently under international criminal law, complicity in an international crime is a crime in and of itself. So you could ask how many companies are actually committing crimes themselves. Well, complicity, aiding and abetting other actors to commit such crimes is also a crime and a serious human rights abuse. So again, going back to what I see as the role of business and human rights treaty, it's to set down those minimum standards of behaviour, those fundamental standards of behaviour. It's not to provide, to reflect all our wishes for businesses' human rights obligations. I share Professor Deva's idealism in that regard. I just don't think it belongs in this first, hopefully of many, business and human rights treaties. We should take to heart legitimacy as a requirement for the effectiveness and the utility of any such treaty. On that, let me end there.
Thank you very much. We do have time for questions.
A basic principle here is that a company would be charged with a crime as opposed to a person. It is an individual. Is that correct? Is that what you're...
You could do both.
You can do both, yes. But it's rare that a company is charged with a crime. But would this treaty follow on it? It's the target is the companies and charging companies with criminal offences.
Right, so it's a good question. So that doesn't go to the scope, but some other provisions of the treaty, and largely it leaves it up to the states. So again, at the current draft, it devolves the responsibility to place business human rights obligations on business onto domestic law. So it largely would depend, but yes, ideally there would be accountability for companies, not just individuals, which does pose all sorts of...
And how far would you anticipate that would go? Would you sentence a company to death?
Yes.
Because
You're asking me? I mean, it depends on the
Why
crime,
not?
right?
I mean, if the crime is so egregious,
Of course.
then this company is shut down, closed, assets dissipated, wiped out, destroyed.
Right. I mean, yes.
Mhm.
Why not?
Okay.
Right. So to give you a historical anecdote, World War II. We've all heard of the Nuremberg Trial. There was actually a series of subsequent trials at Nuremberg, including some that tried German companies. In particular, though, it was German corporate executives that were in the dock, not the companies themselves. At the same time, though, the Allied powers dissolved all the companies of whose executives they were trying. So IG Farben was actually formally and legally dissolved.
Well,
as
just
television
an aside, what about IBM that provided the punch cards for all the racial profiling for the Nazis? I mean, IBM wasn't prosecuted and destroyed for that crime.
The story of business and human rights is obviously that the business wins. But we're trying to change that, right, with a treaty and with this dialogue around business and human rights. So obviously there's more businesses that get away with murder than are actually held to account.
Okay, I interrupt for a second question. Vicarious liability is a major issue here. Right now, supermarkets in, say, United Kingdom are being accused of liability for the deaths of fishermen or slaves in Thailand. For they are tricked into working on the fishing boats. They're not paid at the end of the season. They're just murdered, and then but the product ends up in a supermarket in the UK through a chain of through the logistics chain. So should a supermarket in the UK be punished for the murders on the fishing boats off the coast of Thailand? How far does vicarious liability extend here?
For the consumer as well.
Well, yeah, you ate those prawns, therefore you're responsible for the deaths of those
I didn't eat
fishermen.
those prawns. Are you confessing?
I was complicit, I ate the prawns, yes.
So good question. So let me deflect a little and then I'll try and answer it too. So my approach to this whole area of business and human rights is akin to Kofi Annan's and Ban Ki-moon's, is that we should be seeing businesses not as the enemy necessarily, but as partners. And so properly calibrated, I believe that businesses can be a force for good and human rights protections. So that's one thing. But supply chain due diligence and supply chain, human rights abuses in the supply chain. The reason we do that is because human rights activists can get at the Tesco's and I don't know the supermarket chains in Hong Kong, sorry, but you know, the Coles and the Woolworths, they are consumer facing. So they are they're not immune from consumer pressure, from civil society advocacy, from awareness campaigns of these human rights abuses. We can't get at that Bangladeshi industry or down the supply chain. So to place responsibility at the end or the head of the supply chain and say go down, I'm not opposed to that. Whether or not you hold them to account, you see, is to me a secondary issue. Ideally, we should be going into their boardrooms and talking about human rights due diligence through not just their operations, but through their supply chain to prevent those types of things occurring. And indeed, there's folks out there that are trying to build the business case for human rights due diligence and human rights compliance. You have, if you go to your supermarket, you'll see some fish have sustainable fisheries stamps all over them. They're usually more expensive. The point is that consumers have a choice and that they could choose to not be complicit in those dodgy sourcing issues. Not sure I totally answered the question, but when it comes to the hard question of accountability, at the end of the day, you go after who you can. You know, don't we teach that to our law students, right? Torts 101. You go to the company with the deep pockets, but you also go to the company that you can get at and make change. You see that, so going back, if I may, exactly this point, I'm not deflecting, I promise, so that first task about the iPhones and 3T plus G, so those minerals are called conflict minerals. I'm not sure if people have heard of them. There is now current legislation in the US, and it's about to come in the EU as well, that companies that wish to sell an iPhone in the United States has to declare whether or not they use minerals from the Democratic Republic of Congo or surrounding countries. It doesn't prohibit them, doesn't ban them, but you need to publicly declare that your entire supply chain, whether or not there is any conflict minerals in the supply chain. That was passed in 2012, 2011, geez. It was section 1504 of the Wall Street Financial Reform Bailout Bill. It was snuck in at 3 a.m. But the instant that passed, what did Google, Intel, IBM, what did all the tech companies that use 3T plus G do? They voluntarily declared that they would be conflict mineral free. And they invested tens of millions of dollars in an auditing program to verify that. So it's not all about holding companies to account in that adversarial manner.
I'm skeptical about the conflict minerals. I mean, I do have a technical background. I understand the exact technical issues here, and the tantalum that comes from the Congo is, if you can't get anywhere else, then you have no choice.
I think Australia has a bit of tantalum. Come to Australia. Okay. I agree, but so what they did, they didn't necessarily leave the DRC, but they did place all sorts of human rights due diligence controls all the way down to the local mine. So now and these reports are freely available. They set up what's called the Conflict-Free Sourcing Initiative, CFSI, and for some you can literally trace from the mine to the specific iPhone.
Yes, but also forget iPhones, forget phones. Yeah. It's every electronic device.
Yes.
Televisions.
Yes.
Industrial motor controls. Everything.
Indeed. But shouldn't we as consumers be thinking about where our products come from? And shouldn't the companies that sell those products to us have some responsibility about the human rights abuses that are occurring at the other end of the supply chain?
Could I ask, maybe this is a follow-up question, but a broader question about enforcement. So, I mean, the Rome Statute, I wouldn't say was necessarily easier to get through than international UN core human rights treaties, like CEDAW, for example, which are almost universally ratified. So, I mean, the idea of placing these issues within an international criminal law context rather than an international human rights law context, I mean, I'm not sure I'm entirely convinced that would this be, these crimes would be justiciable before the ICC, or is there some value in developing more of a human rights approach with a treaty monitoring body? That's a little bit, it's not soft law, but it's a little bit softer than, say, the International Criminal Court.
So I think we should do all of the above. So I'm not suggesting that we shouldn't have a business and human rights treaty. I'm not suggesting we should amend the Rome Statute to better incorporate businesses, because there are limitations on the Rome Statute. And I don't see this actually as an international criminal law proposal. I see this as a pathway to improve human rights compliance of business. So a treaty mechanism, a committee, a group of wise people that come out with advisory opinions. I think all of those are wonderful. An individual complaints mechanism should and could be part of any business and human rights treaty. Some current international human rights treaties don't have individual complaints mechanisms. I mean, talk about a dead letter. So yes, CEDAW, with respect, CEDAW and convention that I'm really passionate about, the Convention on the Rights of the Child, the most highly ratified of all human rights treaties. I think it's the US alone now.
Now it's still in the US.
That has yet to ratify CRC, the Convention on the Rights of the Child. Why is there such high ratification levels? Well, I would submit because there is a lack of enforcement in general around human rights. So do we want to repeat that? Do we want to repeat the ineffectiveness of other human rights treaties, or do we take this opportunity to craft something else? The advantage of putting it on international criminal sort of language is that it exposes the possibility of companies and corporate executives to be held account in The Hague, directly under the Rome Statute, without any further legislating required. And many countries that have adopted the Rome Statute as part of their domestic law already on their books have companies and their executives can be held to account. So in terms of asking signatory states to any business and human rights treaty, do we want to ask them to do a heavy lift, i.e. implement broad, far-sweeping new legislation about businesses' human rights obligations and all the related accountability infrastructure that would be required to give life to that? Or do we piggyback off existing instruments and accountability pathways? I prefer the pragmatic approach without sacrificing the principles either.
So following up on some of these, one thing when it comes to sort of these IR theories of international treaties and their effectiveness, and especially focusing on the component of adherence, it's asking as if there's sort of like this is a design decision that we're making ex ante about how we're going to put these things together, where these qualities are essentially tautological, right? If you can get people to, there's high levels of normative dissensus around these issues, especially when it comes to corporate criminal liability. So the fact that these things are broad is because that's the only thing you can get people to agree upon. And it's not that they can't agree upon them, and if they had strong enforcement mechanisms, then they would be more legitimate. It's actually strong enforcement itself is illegitimate in the sense that people can't agree. So that's one set of questions. And then the second set of questions is, if you're going to use the international criminal sort of framework to think about this, then we have to then look to the actual enforcement of the international criminal context. So if we look at the ICC and the ICCJ, so maybe we'll have some prosecution of executives of African countries and African multinationals to the extent they exist.
Yeah.
But if you look at the major players who we're concerned about here, the United States and let's just say China, right? That's a regime that's completely ineffective towards restraining those. Now there are market alternatives that might restrain, American-based companies, right? And then you can get that through that sort of the motivation of the maybe still not to be implemented. The mineral sort of sourcing legislation under Trump may go away exactly because of this census issue. And so it's like the major players who we're concerned about are not getting prosecuted to begin with, right, under that regime. So their corporations are certainly not going to get prosecuted in a more contentious sort of like environment. So I think that goes to like, we're just sort of, these treaties reflect the reality rather than sort of the design decision. And then the major players who we're concerned about are not going to be effectively reached by the sort of putting it in the international criminal context.
Okay. So one academic skill I've yet to master is writing notes whilst questions are being fired at me. So I apologise if I don't capture all that. I really appreciate those comments. If I can put words into your mouth to simplify what I think I heard, it's very similar to what Professor Suryadeva said, that he's willing to have a dead letter treaty. He's willing to have a broad scope international human rights treaty that says businesses should have obligations to respect all international human rights, even as he acknowledges it will never ever be implemented in any way, shape or form. I'm not willing to do that. So for me, it's a relative argument. So many of you, the criticisms that you said, again, could be levelled against all treaties, the legitimacy of all treaties and the trade-offs between that need to go into treaties. I think, again, pragmatism should win out without divorcing it from the principle and the aspirational goals of the business and human rights movement and the human rights movement writ large. Geez, where do I begin?
So just to follow up on that point, the other alternative is to not have a treaty. So I think like the idea that like Shapiro and Hathaway have of like outcasting, that people you can sort of like norm shame and there's some effectiveness to these things. I think in the current, like just the last few years, there's not a real like sustained empirical basis for it. So it'd be better to have no treaty than a dead letter treaty, because that just provides ideological cover. And if you can't have a specific treaty because of the sort of the political conditions don't exist, then just don't engage.
And
in
I'm proposing a middle road, right? I'm proposing what I think is a middle road. So whilst you perhaps don't like the idea of being, perhaps corporate capture of why should we care what businesses, if businesses would like this treaty or not, that's not the principle. We should, maintain our normative purity, if you will. These are ideally, businesses will not be held to account for their human rights abuses, but businesses would proactively protect and respect their human rights obligations. So if that's the goal, again, gaining their support at an early stage, just as the UN guiding principles have, just as some regulatory approaches have, I think we should be borrowing from those. It's not to say that I don't have misgivings about this approach, but I see it as the only viable pathway to push forward. We don't have a treaty at the moment, we've got the guiding principles. I think if that was the end of the business and human rights story, then business and human rights discourse is a failure. Guiding principles at the moment, businesses get to pick and choose. There is all sorts of accountability and enforcement problems around the UN guiding principles. When it comes to international criminal law, if I may, so just because I use the term international criminal law doesn't mean that the accountability has to happen through criminal means. It also exposes a company and its executives to civil liability, alien tort statute, and comparable civil lawsuits around the world actually demonstrate the utility of that approach to corporate accountability for human rights abuses. It's been sharply curtailed by the US Supreme Court, which is unfortunate. But companies have been held to account, are being held to account, are being exposed to all sorts of reputational as well as legal risks through civil liability, not just the International Criminal Court. And my final sort of rejoinder on that is the International Criminal Court was always supposed to be a court of last resort, right? It was premised on the notion of complementarity. So if we're going to critique the International Criminal Law Project, I would put the blame more on states failing to follow through, right? Ideally, it's domestic courts that should be holding international criminal actors accountable. They've absolved themselves of responsibilities and just shunted people off, left that responsibility to The Hague, which is underfunded, overworked, and I agree has all sorts of political legitimacy issues. Totally agree with all of those points.
Okay, well, I think, one more question.
So we're talking about the international, multinational companies and the victims of the countries where the money is poured in. But I think there's like elephant in the room, the host country regulators. So from the international investment law perspective, when a foreign investor invests in that specific country, the host country regulator has the power or authority or sovereignty to review or conduct times of like environment review, like labor standard reviews, before they admit or give the permission to the multinationals before they invest in that country. And ex post investment, under the investment treaties, the host country regulators also have the authority or the power to stop or correct the wrongdoing of these corporations. So if we consider the detailed mechanism of the whole investment, I think why not like shift all the pressure on the corporations, on the host country regulators instead, because their legitimacy are built on their ability to protect their own nationals. So what do you think?
So my response to that is simply power dynamics. That so often in those investment scenarios, the company has a lot of the bargaining power, and in fact a lot of the regulatory constraints that might otherwise be there in the negotiation to bring in that foreign investment actually get whittled away. Also those the host states where the foreign investment is coming in, I think is the wrong target. Again, because of the power dynamics, because of the economic wealth, because of the need for development in so many host state countries in the developing world. Better to go again, I think, at the home states as the target of these regulators. After all, where these companies are domiciled are supposedly the ones that have the responsibility to regulate them.
But how to target the home state? Because so many multinational, their home state are, especially the parent control holding state, are in Cayman Island or these tax-free heavens.
Yeah. So this is again a problem in terms of the adversarial style accountability in a court of law. But this is a perennial problem again for any type of corporate litigation. It can get overcome, the notion of a conglomerate and parent subsidiary liability. These are issues that are well debated, and courts do find ways through those hurdles.
There are many successful cases of parent companies being prosecuted for offences that a subsidiary, foreign company has been that has done.
Yeah, but today the multinationals, their shares are so diverse, so it's really hard to define where is the control, like the home country.
Well, there have been successful cases. For example, asbestos mining in South Africa causing asbestos poisoning to the workers. The South African company folded, but there was a successful prosecution of the parent in the UK because it was proven that there was control. There are many similar cases. An American company making faulty breast implants, for example, was prosecuted for products that sold internationally. So there are cases. And then the Alien Tort Act for ExxonMobil in Burma, although they settled out of court, so the judge couldn't make a ruling. But there are many such examples. It's not easy, but it has happened.
Okay, I think we really are actually out of time, but thank you very much, Jonathan, for the excellent presentation, a great overview of the issues, the real issues, and some of the possible solutions. I think, as I predicted, it was quite provocative, and a great discussion, so thank you very much. Thank you all for joining us. Oh, I can imagine.
So you agree that there isn't a whole lot of disagreement between us, actually?
We should from water.
It's nice to see you in person. Thank you for the presentation.
Thank you.
And you sound really, really nice and genuine, I would say. Like, we have a lot of listeners coming over.
And what about his
Oh, thank you for participating.
Thank you very much. You got a reference on international law and enforcement and why countries accept international law. Professor or
Oh,
Thomas Franck.
There's a lot of
no, I didn't get that.